There we go. Okay.
Yeah. Right, good evening, ladies and gentlemen. Thank you for being here. This is our second cannabis seminar of 2018. We held one earlier this month, and we had to do a second one by popular demand. My name is Paul Michael Keichel. I am a partner at Schindlers Attorneys. I've been involved in the cannabis case since the Dagga Couple joined us in 2013, but I'll tell you a little bit more about that later on. I'm going to be handling a few introductory aspects as to how we got involved in the matter, what the law was prior to judgment and what the law was post-judgment. To my left is my colleague Andrew Lawrie. He is a candidate attorney at Schindlers, and he'll be taking over from me and telling you the intricacies of the law, those finer details that I won't really cover in my introductory portion. And to the left of Andrew is Kyle Telfer. He's an associate at Schindlers. He's been involved in the Dagga matter as well for a number of years. He's not going to be speaking to you initially, but at the end of the seminar, we're going to be opening up the floor for some questions, and Kyle's going to be fielding some of the questions for us because he likes to debate and argue with people. So that's well, there we go. We've got the client himself who can attest to that. So I think without further ado, let's get on with it. So as I said, we will open up the floor for questions, but if there's something that you really don't understand during the seminar, please feel free to interrupt me. The only caveat is that you must then remind me where I was. Because if you get me lost, then everybody's going to be lost. So this has been a long journey, and obviously you guys are all here for different reasons. Some of you just want to know whether it's legal to smoke at home, what it means, what is a private space, how much cannabis can be used for personal consumption. Some of you have industrial ambitions. Some of you want to grow some industrial hemp and knit some socks. It's completely up to you, but how we got involved is actually quite a long journey, which started in when would it have been? I think 2004, end of 2004. I'd just completed matric, and I went on a trip, Euro trip with my brother, and part of that trip was Amsterdam, and I found myself in a coffee shop smoking a rather large joint, quite a potent one, and enjoying myself, and thinking to myself, wow, isn't this incredible that I'm in this relatively functional society, the sky hasn't fallen, we're not surrounded by dysfunctional drug addicts, and I also feel a lot less intoxicated than I do when I drink alcohol. So that was really the genesis, and I then went to Rhodes University and I started studying law, and I took Introduction to Law, Introduction to Constitutional Law, and then the juices started flowing and the ideas started forming as to how could we possibly structure a legal argument for the decriminalization or legalization of cannabis in South Africa. And fast forward to 2009, I had opportunity to do constitutional litigation. And strangely enough, it's actually, this is a departure, but it's the fault of this man sitting here, Cameron Billing, because the year before he had convinced me to go out with him at the end of exams instead of studying for my exam, and I failed that module. And it was only from failing that I then needed to create a timetable clash in my final year of law, and the only thing that would create a timetable clash and mean that I didn't have to sit another round of lectures was to take constitutional litigation. So cannabis is actually decriminalized today because of Cameron Billing. Yeah. I'm not sure he even remembers that. So I wrote this essay in 2009, and one of my main sources in the essay was a gentleman by the name of Craig Patterson, who is a historian, and at the time he was studying at Rhodes, but he was described by the HOD of the history department as knowing more about the topic of cannabis history in South Africa than anybody else. And he provided a lot of material for the essay, but once I'd finalized the essay, he also had a final draft, and with my permission, he provided that essay to some of his friends, being Jules and Myrtle of the Dagga Couple. And fast forward to 2013, the Dagga Couple actually found themselves at Schindlers Attorneys, having been sent here by the pro bono.org department in order to register their non-profit company. So they weren't in fact here to see me. They were speaking to another colleague of mine who then said, well, hold on, you need to speak to this chap, Paul Michael. And bells started ringing in their heads, and they realized that I was the author of this essay. So I was called down, and to cut a long story short, they had been looking for legal representation in their cannabis challenge for a number of months, and had been turned away by a lot of law firms. And through some begging, pleading, and pulling of some strings, we decided to take them on pro bono. And it was a serious challenge, and what happens with constitutional litigation is that although there's a reverse onus, with something like this, and I'll explain the reverse onus in a moment, you need very strong evidence in order to prove this, because there are these questions as to the harmfulness, the medicinal effects, the societal effects, what it's going to do or not do for our economy, the historical rationale for prohibition, etc. So we knew immediately that we needed a very high caliber of expert witnesses. And the person who was assisting us at the time was the late Robin Stranson Ford, Advocate Robin Stranson Ford. Now, he was very good friends with Dr. Mario Ambrosini, who some of you might remember was the IFP chief whip who actually stood up in Parliament, put forth the Medical Innovations Bill, and came clean to the whole of South Africa that he himself was a cancer sufferer and was using medicinal cannabis to alleviate his symptoms and to treat his cancer. And Robin Stranson Ford was a very good friend of his, and there was, as you would all appreciate, those who either partake in cannabis or who are for cannabis all speak to one another, and it was Robin who ended up being our advocate, and who told the Dagga Couple, in fact, that they needed to register this NPC. Actually, that was their former attorney, for very reason that you would need this high caliber of expert witness, and this is going to cost a lot of money. The sort of money that you can't just expect two individual litigants going up against government to come up with. So we get all of our ducks in a row, and with the trial set to run in 2015, we file our expert witness summaries, which is it's a legal requirement that you have to do. You have to notify your opponents that these are the experts who we're going to be calling, and this is what they're going to say, and that gives them the opportunity to study those and to come up with contrary evidence and contrary arguments. And it was at the 11th hour when we were supposed to exchange these expert witness statements that the state said, well, hold on, we're actually not ready. Well, if you read between the lines, we don't really know what we're doing here. We need to scrounge around and find people who are willing to speak on our behalves. And they convinced the Pretoria High Court to give them another 2 years. So we had the trial set down for 2017. The other thing that would transpire the state wasn't ready for is the so-called reversal of onus. What happens in usual litigation is that if you're the plaintiff or if you're the applicant, as the saying goes, he who avers bears the burden of proof. So if you're making the allegation or if you're making the claim, it's up to you to lead all of the evidence to justify it. But constitutional litigation is slightly different, because all that you need to do as a litigant in constitutional litigation is to say, well, I've had one of my fundamental rights as written in the Constitution infringed. The onus then shifts. It then becomes the state's onus to prove that that prohibition is rational and justifiable and reasonable in the circumstances. There's a whole test which is set out in Section 36 of our Constitution. And for whatever reason, it seemed until only about halfway through the first sitting of our trial that the state seemed to deny that this was actually their onus. And what would ultimately transpire is that we went to trial at the end of July 2017, July running through August 2017. And we started, after some very annoying scuffles with the state who didn't want us to live stream, go figure. They didn't want this evidence being out there in the public domain. We got underway and we started leading witnesses. And unfortunately, one of our main witnesses, Dr. Donald Abrams from San Francisco, had to fly home because the state had wasted so much time. And we were able, though, to lead the expert witness testimony of Professor David Nutt. May I presume that everybody's familiar with Prof. David Nutt, what he has to say on the scale of harms. And we led Craig Patterson, the man who was my main source in the essay and who also gave my essay to the Dagga Couple. Unfortunately, it was rendered part heard because although we had allocated a month to the trial and we thought we were going to finish within a month, the state, when they finally woke up to the fact that they were facing this huge challenge and they had this burden, and realizing that they were unprepared to meet that challenge, decided to just flood us with as much documentation as possible. So in the space of about a week, we were hit with upwards of 4,000 pages of every single study under the sun, which, upon later analysis, 99% of which actually supported the case that we were making. But that was their tactic, and unfortunately the trial, well, that portion of the trial concluded in August 2017, and we were then left a little bit in limbo because we had run half of this trial and now we needed to apply for another date. And even if you get an expedited date, you're talking in the region of a lot of months or even a number of years with another month of the judge's time to hear this kind of matter. But in the meantime, as all of you know, there was that matter in the Western Cape High Court that was heard or we had judgment, I think, in February of 2017, which was Judge Dennis Davis and two other sitting judges, a full bench, where they had essentially ordered that the laws prohibiting and cultivation of cannabis at home by an adult in private are unconstitutional, and that was now going on appeal to the Constitutional Court in November of 2017. So while there's the intention of carrying on with the trial, we realized that we would be somewhat naive if we didn't intervene in that matter, because not amiably far on their own, but Gareth Prince and Jeremy Acton, etc., were unrepresented individuals. So they were legal lay people, and while they had a significant amount of evidence and they knew what it was, or they knew what the rights were that they thought were being infringed or that they alleged were being infringed, they weren't really able to construct a coherent legal argument of the sort that constitutional court judges are used to dealing with. And we were a little bit concerned that if we left them to just run that appeal, we might be left with a we didn't like. And this is a judgment of the highest court in the land, which then could have a contrary effect on our judgment. So we managed to intervene, and it was in November last year that we presented argument, as did Gareth Prince and Jeremy Acton and the Keichel tried to intervene, etc., etc. And that's the judgment that ultimately resulted earlier this year, in September this year, which decriminalizes the personal and the personal possession and use and cultivation of cannabis in South Africa. So where this takes me to next is a question of, well, what was the law before that judgment, and what is the law after that judgment? And unfortunately, the conclusion this evening is that not really all that much has changed. I mean, it's changed a lot for the average cannabis user who really just wants to sit at home on his couch and get stoned, but it was all on the basis of the limited right to privacy that this happened. And so when it comes to industry, etc., as I'll take you through, not all that much has changed. Now, in terms of the personal use and possession of cannabis, prior to the judgment, you would refer to the Drugs and the Drugs Trafficking Act, sections 4B and 5B. And there is a general prohibition on the use and possession of cannabis, and there is a prohibition on dealing in cannabis. Now, dealing is widely defined. I'll take you to a slide a little bit later so that you can read that. But what is interesting under sections 4B and 5B is that the prohibition is only about 3 lines long. I'll read you in terms of the use and possession of drugs. It says, no person shall use or have in his possession A, any dependence-producing substance, or B, any dangerous dependence-producing substance, or any undesirable dependence-producing substance. That is the prohibition. And you've got a mirror provision in respect of dealing in section 5B. But then those 3 lines over there being the prohibition, you've got the word unless. And then everything follows underneath it. And this unless in both 4B and 5B is the real mouthful, but I'm not going to take you through it, but what you see even prior to this judgment is that there are a lot of references to the Medicines Act and a lot of references to pharmacists and dispensing, etc. So already now, they had it in mind, although not specific to cannabis, that in certain circumstances, if you have the right licenses through the former Medical Control Council, now SAPRA, and through the Pharmacy Council, there were these exceptions that would allow you to get your hands on prohibited substances. What everybody used to talk about back then was the so-called Section 21 application, which was to say that, well, if you're really, really sick and there's nothing else that's going to help you, then through your doctor you can make application to use cannabis or any other unregistered medicine. The problem with that, of course, is that with so much red tape and with the stigma attached with cannabis, there were no such licenses that were granted for 2 reasons. The first one being that it was incredibly difficult to demonstrate, as was one of the requirements, that there was no other medicine which would do the same thing. So, for example, if you were an epileptic, it would be very difficult to say to the MCC, well, I'd like to use cannabis for my epilepsy. They would say to you, well, you can use Tegretol or whatever other medication. The other problem associated with it was that it doesn't allow you to just use anything like cannabis. Cannabis is what will later be described by Andrew. It contains things called APIs, active pharmaceutical ingredients. Those ingredients are then used to manufacture a medicine. So you now have a medicine that's not registered here, but in order to get it in terms of Section 21, you need a medicine registered overseas. So it's not just a case of, I want cannabis, and then you can import raw bud from overseas. You would need to have found at the time a cannabis-based medicine, such as dronabinol. There was one such medicine that we knew of that existed back then, which you could then import. But what we know is that certainly no licenses in terms of Section 21 were granted that we know of. If any of you know of anybody who historically got one, please bring them to us, and then I will alter this presentation. But that's what the Drugs Act said. There was also the dealing provision, which, as you know, you're prohibited from dealing. Everybody understands that dealing is the exchange of cannabis for money, and there are other nuances to that. But there was this presumption, which was that if you were caught in possession of 125 grams of cannabis upwards, you were presumed to be a dealer. And what that meant was, again, one of those reverse onuses where instead of the state having to prove beyond reasonable doubt that you were dealing in cannabis, it was presumed that you were dealing in cannabis, and then you had to present all of the contrary evidence to show, no, I'm actually just a heavy smoker and I was storing for winter, or whatever the case may be. Now, CBD has only recently started emerging as something that is considered traditionally separate to cannabis. Well, not separate to cannabis, but largely when we talk about cannabis, we always think about getting stoned and THC. And it's in the last, what would you say, Jules, in the last decade that people have started waking up to the fact that there is
6 years.
6 years, people have started waking up to the fact that there are all of these other compounds, cannabinoids, that exist in the cannabis plant, each with their own uses, etc. And we're not going to get into this whole argument about the entourage effect, that you really ought to be using them all together in order to achieve the same purpose. But CBD has been isolated, and certain positive effects have been associated with it. Now, it was actually prior to the judgment. In fact, I believe just before we argued in 2017 that there was this move by the MCC to reschedule CBD. Andrew's going to explain to you what that rescheduling means, but what it says is that, I can move on to one slide, even though it's not the correct slide yet. That's Section 7 of the Medicines Act. I'll move on to that for hemp fiber. It's been moved to Schedule 4, so it remains in Schedule 7, but in Schedule 4 it says that it's Schedule 4F for medicinal purposes, which you start entering into this debate of, well, if it has medicinal benefits and the World Health Organization has acknowledged that it has no psychoactive properties or negative side effects, what's it doing scheduled at all, and how could it be for anything other than medicinal purposes? It's like suggesting that you're drinking water recreationally. As somebody in the room who's present here once pointed out to me, water, I suppose, could be recreational if you're using it to flush MDMA out of your system. But that's more of a joke than a real argument. but it does highlight the absurdity associated with leaving something that's non-psychoactive and non-harmful as a Schedule 4 substance. But bear in mind that all of these scheduling and all of this scheduling and these regulations in the Medicines Act, these are all throwbacks to a time long ago when people hadn't woken up to the possible medicinal qualities associated with cannabis and other psychoactive plants and chemicals, etc. So bear in mind that we are dealing with really old regime laws. So that's what happened prior to the judgment in respect of CBD. Hemp, this is where my slide comes into play. This was one of the exceptions to Schedule 7. But what you see in respect of hemp is it doesn't really help you very much. It doesn't mean that you can grow it, because it talks about processed hemp fiber containing 0.1% or less. So given that you need something to process in order for it to be processed, and then it's going to be unprocessed before you process it, what that really says to you is that you can't grow hemp in this country. So what this says is that you can import processed hemp fiber. So there is no real hemp industry in South Africa. You can import some fiber, knit your socks, do whatever you want with it, and then on-sell it, but only if it meets those strict criteria. There were certain instances of people getting licensed to grow hemp, but it's always been in partnership with the MCC and the Department of Agriculture, and then they get this so-called research permit, which was that they would give them permission to grow, call it an acre of hemp, and then every little gram of fiber or of biomass that was grown then needed to be given to the Department of Agriculture or to the MCC for research purposes. And then they would say, all right, well, we're doing a viability study, and then years later there would be no result and nobody's heard back. And then all of this money has been put into growing this hemp field, and there's been no payback and no progress from a legal or legislative perspective. So those are how we define it. In our speech, really, we've got cannabis, but there we're really talking THC. When we talk CBD, we're talking non-THC and separate to the entourage cannabis plant. And then we talk hemp. So we have this judgment earlier this year, what does it really mean? And we have the personal use by adults in private. And they also start talking about cultivation. It means what it sounds like. It says that in the next 2 years, while, well, the judgment declares certain portions of sections 4B and 5B and certain portions of the Medicines Act as unconstitutional, to the extent that they prevent an individual from consuming and cultivating in private for their own use. But in those 2 years, it is a defense to a charge under those that you are doing it for those purposes. So then, of course, we ask the question, oh, sorry, that's the rescheduling that we were talking about. So you see that's Schedule 4, and then it says cannabidiol when intended for therapeutic purposes. Then there's the reference to Schedule 7, so it remains up there. So this is this is really what got everybody excited. This is the real change to the law. There's not much outside of this that constitutes a real change. And you'll notice that what it says is invalid to the extent that they make the use or possession of cannabis in private by an adult for his or her own consumption in private a criminal offense. So then we ask ourselves, well, what does this mean? What is in private? The Constitutional Court goes into quite a lot of detail as this around this debate, and they say, well, privacy, or the concept of what is private, is like an onion. It has many layers. But to cut a long story short, a private space is not limited to the home. There are going to be private spaces outside of the home, although they don't give you a definite list of what those are, or even a genus of what those are. And they also acknowledge that people are going to be moving between private spaces with cannabis on them. So what can we infer from that? Well, you certainly can do it at home on the privacy, in the privacy of your living room, so long as there isn't a youngster around you or a non-consenting adult. And then, hypothetically, you want to now go and meet up with your friends at your private cannabis club, and you want to take your cannabis with you. Well, you can put it in your pockets, or you can put it in your backpack, because those are private spaces. Although you're moving through, it renders it private. So we're reasonably confident in telling you that that's what the judgment means, but of course, as Jules will tell you, the cops and the prosecutors certainly haven't woken up to this fact yet. So don't rely on what we tell you as sacrosanct, although we are 99% sure that we are right on this. It doesn't stop you from getting arrested. Ultimately, this is only going to be a defense if they decide to prosecute you.
Does a car count as personal space?
We believe it does. We believe it does, for the very fact that, for example, at a roadblock, they need reasonable suspicion or a warrant in order to be able to search your car. So yes, it is. They need to have reasonable suspicion that you've committed an offence, and carrying of cannabis in your car wouldn't be an offence. In fact, just going back to a story, and I can't remember who exactly it was who told me, not that I could tell you anyway, but she was driving home one evening, and she had, I don't know, 2 gram banky of cannabis sitting in the center console, and she was pulled over at a roadblock. Have you had anything to drink? No. Do you have anything, well, do you want to declare, have you done anything wrong? And she said, well, I actually do have some cannabis in the book that this was so forthcoming, but ultimately the police officer just sent her on her way. Didn't arrest, didn't search, nothing of the sort.
When did that happen?
After the judgment. After the judgment.
Doesn't mean you can smoke and drive, though.
No, it certainly doesn't mean that you can smoke and drive, because that's a separate crime. Driving under the influence of drugs is a separate crime, and nothing in this judgment has done away with that being a crime. What is personal? Well, sorry, before I get on to what is personal, this is the definition of deal in prior to the judgment, and you can see it's not only the exchange of cannabis or of drugs for money. It talks about all manner of concepts: transshipment, importation, cultivation, collection. What the reading in has done, really, and this is I think paragraph 11 of the order, is that after cultivation, but before the comma, they've put in that whole blurb, unless it is for personal